Okay, we'll start the last part of this afternoon with the third panel. Again, three persons, three experts, but with different backgrounds, so I think it would be helpful with the discussion. The idea is really to initiate the discussion then with the audience so that we can finish quarter to 6, the latest 6. So, we'll have a very short introduction, it's more point of view, and we'll start with competition lawyer, and then the economist, and the patent lawyer. That's the order you decide?
Okay. That's fine.
So, let's start with the competition lawyer, and then the economist.
Okay.
If you want to know more about them, again, look at the biographies in your documents.
Do you want us to stay here?
Yes,
okay.
I think it's better for
because we want to have this, congratulations on staying so late on a Friday for such a, but it is a fascinating subject, I'm sure you agree. I'm a competition lawyer, and I just wanted to make a few remarks today about the theory that the Commission, the legal theory the Commission uses in these cases. Some of this should sound familiar to you by now because I pick up on some themes that you've already heard. For instance, all of you now know what a turducken is, so I won't go much more into that. But that's one of my favorite metaphors for what's going on. So the Commission's theory is what's called a bi-object theory. I don't know if you students are competition law students or IP students or French literature students, but okay. A bi-object restriction, you have two theories you could pursue, bi-object or bi-effect. And there have been books written about what these things mean, okay? And I will try to simplify it. I'm surely oversimplifying it. But a bi-object restriction is one that's by its very nature, the agreement restricts competition. So it's clear, you know it when you see it. The best example of a bi-object restriction, the classic example, is a cartel where you fix prices. You don't have to analyze the cartel to see whether it's bad or not. You know it's bad. And so once you establish there's a cartel to fix prices, there's a competition law infringement, and you don't need to do further analysis. There's some, and so you've got cartels. You've got other kinds of agreements that over a course of time, you've had a number of cases, and experience tells you that this kind of agreement is bad. So those are bi-object restrictions. And you also you've got a new line of cases, and this is what complicates this a bit. You've got a new line of case law about bi-object restrictions that say you have to kind of dig into the agreement a bit more and analyze it. But still, it's something that's very obviously bad. What difference does it make whether you pursue a bi-object case or bi-effect case? Well, one difference is the Commission doesn't have to prove negative effects. It just has to show that you've got a cartel that fixes prices, and that's it, okay? And the Commission wins. In a effects case, you've got to show that the agreement has anti-competitive effects, and that takes a lot of proof. In the Lundbeck case, the Commission is one I'm familiar with. The Commission is pursuing a bi-object theory, and one of our theories is that it's doing that not only because it's easier, it's in effect a shortcut because it doesn't have to produce all this evidence, but in that case, because the case started 10 years ago in 2003, there's not much evidence left. So if the Commission couldn't bring a bi-object case, it would have a very difficult time bringing a case at all because it couldn't find the evidence. My client, you asked them for the evidence, they found a box of documents in the Tennessee Hills in their storage facilities, and that was it. Because these companies had been bought and sold over the last 10 years, and everything had been lost. And that was typical of a lot of the companies involved in these cases. So that's what a bi-object restriction is. Do we have bi-object restrictions in reverse payment cases? Well, I have to say this because it's specific to the Lundbeck case, but I still have to say this. In the Lundbeck case, the agreements took place about 2003 between Lundbeck and the various generic companies. the commission actually looked at those very same agreements back then. And the commission told the Danish Competition Authority, which was also interested in it, because Lundbeck's in Denmark, said, you know, these agreements, we're not sure if it restricts competition or not. It's in a gray area. And the Danish Competition Authority made a short report and posted it on its website. And so when this case started, we found this. And it's very interesting. The commission could say in 2000, and this was 2004, that it's in a gray area. And now, 10 years later, the commission is saying it's so clear it's a by-object restriction. So it seems to me that it's hard to go from something that's a gray area to its by-object now. The commission can change its mind, sure, but it seems like it's difficult. It's certainly difficult to find companies. In this case, it was what, $150 million total, euros total, to find companies when the commission itself back then said these agreements, we don't know if they restrict competition or not. So how would a company be able to know that back then if they analyzed it? Okay, so you've got one issue of what the commission itself said. But think about it, a by-object restriction is one that almost always restricts competition. A price-fixing agreement always restricts competition, or almost always does. But what about these reverse payment cases? Just in the Lundbeck case, again, the one I'm familiar with, the parties had done their own analysis before going into settlement discussions of what we think our chances of winning are. And you had different, you found emails in the file had different percentages, but they varied from 60-40 to 50-50 to 40-60, somewhere in the middle. So it means that if you litigated out the case, you have a 50-50 chance of winning. Maybe the generic wins and can enter the market, but maybe the originator wins and can block the generic from the market, okay? So in that case, how can you say that there's a high likelihood of restrictive effect? The restrictive effect in this case would be keeping the generic off the market when you shouldn't have been doing that because the patent was invalid or there was no infringement. Another point, we've talked about this a bit already, is what's the significance of the reverse payment? Because the commission is essentially saying these cases where there's a reverse payment is by-object restriction, okay? And so the reverse payment is what really raises the red flag. And the commission's theory is the reverse payment is the originator essentially buying off to generic. And why is it doing that? Because it doesn't believe in the strength of its patent. Okay, that's the basic, again, I may be oversimplifying a bit, but I think it's a fair statement that's the position. I think the counter argument is, and Ingrid already referred to this, is the asymmetry of risk. Is the originator has much more at stake than the generic. The originator, and you saw the things that can happen. The price, if the generic enters the market, the price goes down in the country where it enters, and then the way the rules work in Europe, in other countries that use that country as a reference, the prices in other countries can go down. So the price goes down, which means the originator, the price of its product goes down, starts losing lots of profit, okay? So it does a lot of harm to the originator. Even if at the end of the day, if the originator were to win, it may not be able to recoup all the damages it suffered because the generic may not have enough money to pay it. So that's just an example of the kind of cascade effect that can happen, and the originator has a lot at stake. It's got its entire product at stake. The generics don't have as much at stake. So there's a real asymmetry of risk, which explains the payment. Ingrid used the Russian roulette example. That example is often cited to explain what I just said. That is that the originator, even if the originator's patent had a 95% chance of winning, it still might be willing to pay a lot of money not to take the risk, that 5% risk of losing in court, because it has so much at stake. And actually, in actual fact, even the strongest patent, if you have a quote strong patent, it means you have maybe a 70% chance of winning. I mean, patent litigation is notoriously uncertain. So it's very hard to predict what's going to happen. Undercurrent, and I'll stop. There's an undercurrent in these cases and I heard it several times today, there's kind of an assumption that these patents, especially process patents, are weak. You know, they're not the main compound patent, they're a secondary patent, a process patent, and there seems to be an assumption that there's something wrong with these patents. I mean, there's really no such thing as a weak patent. There are patents, and there are patents, and there are patents. And to base a competition law case on the idea that the commission thinks this patent is weak, and therefore it shouldn't be used to keep the generic off the market for an IP lawyer doesn't make a lot of sense. And it essentially is saying the commission is second-guessing the validity of the patent and doing, in a way, its own analysis. And it's trying to figure out what would have happened absent the settlement back then in the Lunebeck case in 2003. And as a U.S. judge said in a very famous case, that's a very hard prediction to make because, I'll quote, it's a great quote, predicting the future is precarious at best. Retroactively predicting from a past perspective a future that never occurred is even more perilous, and it is too perilous an enterprise to serve as a basis for antitrust liability. So, you know, in plain English, what it says is it would be difficult for the commission to rule on the validity of the patent as it's beyond the scope of the commission's expertise in any event, but the difficulty of doing that becomes insuperable if the commission's having to do that based on something that happened 10 years ago. I'll stop there.
I'm Benoit Durand from RBB Economics. I'm probably the only economist in the room, and we tend to become overly complicated sometimes. I'll try to be as simple as possible, but if you feel I am going too high, just let me know. I think just to make clear, and just in case I lose you, the point is going to be very simple. You cannot presume that a reverse payment in a settlement agreement is illegal, or let's put it this way, rather, I'm not a lawyer, so I shouldn't say that, but is anti-competitive. There are actually no reason to think that every time you get a reverse payment, you will always end up in a worse outcome for consumers, okay? And let me explain why that is. So clearly, the type of agreement we're interested in here, or we're looking at, is not the agreement whereby the patent holder and the generic company agrees to extend, you know, the exclusivity of the agreement. Now, what we're looking at is essentially the type of agreement whereby the parties agrees to a settlement and entry may take place within or before the end of the patent life, and there is a payment. Okay, so I'm not discussing any agreement where the parties will extend the life of the patent beyond its own life. Now, the first point you need to realize is that, as far as economics is concerned, a patent right is, in fact, a probabilistic right. Okay, the law gives the patent holder, if you're on the right, to go to sue a potential infringer in court, which means what? That there is no 100% certainty that the patent holder will actually win the case. Okay, even if he feels very strongly about the fact that the generic may infringe its patent, he may not actually win. Okay, so we're not in a world of certainty here, we're in a world of uncertainty. Okay, yes, that's very important. So the first point, which means that analytically you can think that you may have what we call weak patent. What is a weak patent in that sense? It is a patent that has a low probability of winning, and a strong patent will have a high probability of winning, okay, from an analytical point of view. So the whole point of patent law here is to provide protection right in a probabilistic term, okay? Now, that's the first point. I'll come back to it. The second point is, how do you determine how an anti-competitive agreement is going to lead to a consumer welfare, or a loss in consumer welfare, How are you going to determine this? Well, you have to think what would be the world without the agreement. So in the absence of the agreement, what would happen to consumer? Would there be, in the case of patent settlement, would there be generic entry? Because we know that generic entry has this nice property that actually when generic enter, the price of drugs goes down. So it looks like consumer will benefit from this. But the point is, you have to ask yourself, if there is no agreement, would there be generic entry right away? And that's certainly not the case. Okay, why is that? Because if there is a dispute, that means that if the parties cannot settle the dispute and find an agreement to settle that dispute, they will end up in court. And there is no guarantee at all that the court will actually either find that the generic is right or that the drug originator is right. Okay? So in the absence of the agreement, you don't have entry. You don't have immediate entry. You have only a possible probability, there might be a probability of entry. Okay? And so that makes it very different from a cartel agreement, where it's clearly, in the absence of the cartel agreement, we know that there will be price competition. But we're not in this world. Okay, we're in a world where you have IP law, and IP law provides the right to sue in court to actually enforce your patent right. Okay. Now that means essentially that I can only determine whether the agreement is anti-competitive or pro-competitive by determining what would happen in this hypothetical situation when the party do not reach an agreement, which is very difficult, obviously, because that world does not exist. Okay, and this creates a real concern, because this would mean that if the Commission analytically is the right thing to do, okay, now in practice this is a real challenge, because that would mean that the Commission would have to actually become a court of law or patent court of law, which it is not. Okay, you will have to determine whether this patent is strong or not, and which means it has some expertise about this, which it does not have. Okay, so now going on further, third point, if we have a payment, and that's the red flag that David talked about, if we have a payment, does that tell us that actually, gee, we don't need to go through this difficult exercise of trying to determine what would be the date of entry for a generic supplier in the counterfactual world? We could assume that if there is a payment, it must be the case that the generic entrant will actually delay entry because it's being paid for that. And therefore, it's got to be anti-competitive. And here you have to say, hang on a minute. Not really, not necessarily. Okay? There is the idea that you can, if you have, and I'm going to relate very briefly the size of the famous payment and the strength of the patent. In theory, you can think that if you have a very weak patent, okay, and you know that, you think that if you go for litigation, chances are you're going to lose. Okay, so you should be willing to pay a lot. Okay, to make sure that the generic entrant doesn't come in. Conversely, if you think that you have a very strong patent and you have a high chance of winning, okay, then in litigation you most likely will win and therefore keep your so-called monopoly rights. And in that case, you're not really willing to pay a lot. Okay. Now, if you take that assumption, then you get to think, well, gee, obviously, if you have a weak patent, you're going to pay a lot. That clearly means that you're going to delay entry beyond probably what would happen in the counterfactual world of litigation. And that's got to be a bad outcome for consumer, because generic entry would be delayed relative to the counterfactual situation of litigation. Okay? So that seems to be there is a relationship between the strength of the patent and the payment. Now, that looks pretty clear, but in fact, in reality, when you look at the payment, how do you know how high it is? That's also create a real difficulty here. We don't know how high the payment is. Clearly, the payment must be compensating the generic entrant, otherwise he would not accept it. Clearly, he's better off this way. And clearly, for the patent holder, he's happy to pay because otherwise he will prefer litigation. So the settlement must be better. But it doesn't mean that it's a bad outcome for consumer. Okay? Even those proponents who think that the size of the payment matters, they would tell you that even a small payment, whatever that means small, will lead, even a small payment in a reverse payment may lead to generic entry that would happen earlier than in the counterfactual world of litigation. So just the fact that you have a payment doesn't tell you anything, first point. Okay, if you just take the payment as such, it's not an indication that entry will be delayed relative to litigation, okay, the counterfactual. And second, if you think, if you have a formula to actually know how high the payment is and whether the payment will tell you about the strength of the patent, then you're really good. Because most of us don't know that, okay? So I know I'm not very, it's not very practical so far, but I just want to tell you first, the analytical background is very important to understand how you drive policy here. Let me make a number of other points. If you have a settlement agreement, and to jump on what David and also Ingrid was saying, if you have a reverse payment, and this reverse payment may actually end up or lead to a settlement that basically allow generic entrant to come in earlier, how that can be? Well, very simply, and everybody says that, but we're going to repeat it. First of all, if you have a patent dispute, that means people don't agree, okay, clearly on what the outcome of litigation might be. Okay, so they may have very different view on their chances in the counterfactual world if they go to litigation. You may have a situation where the generic entrant is actually very optimistic about its chances, maybe a very optimist, or maybe it's cash strapped and he doesn't have the time to wait to settle things. I mean, at least to think that he thinks he has a good chance to make money on the market, so he wants to go in right away. And on the other hand, you may have a patent holder that has actually maybe a few blockbuster drugs, maybe this is the blockbuster drug that is responsible for most of his income, and therefore, if it loses the profit from these drugs, it would be a devastating outcome for his future research. You can imagine it's not exactly a completely unrealistic situation. And if that's the case, obviously we heard about Russian roulette. There is the idea that if you go to litigation, as I said, it's very uncertain what the outcome of litigation is. Even though you think that you have a good chance of winning, you may still end up losing. So maybe it's not a Russian roulette, it's just rolling a dice, but still it's as bad as this. It can be, you can still lose. So in that case, what do you prefer to do? Most people are risk averse. Okay, you all prefer a certain outcome to an uncertain outcome. Even if I tell you, even if we give, there are experiments out there that shows that people actually prefer a lower income that is certain than a higher income that is rather uncertain. So we know that there is a risk aversion, and for firms the same thing. So people will prefer a certain outcome, and so forth. That explains why firm may be willing to actually settle, and even though they will have a good chance in court. Okay, that's called a risk premium. You pay for it. That's a cost to you. Okay? So for all these reasons, you may end up in a situation whereby the two parties will be better off, clearly, by settling, but actually enabling the generic entrant to come in earlier than otherwise. Okay? This is actually a situation that clearly can arise. The last point I'd like to make, because I think it's pretty important, in Europe in particular, what you see is, you see often many generic entrants. You don't see just one. So it's not a situation about, I'm going to sign up one generic entrant, I'm going to be fine, and no one else is going to try to come in. Often you will have several generic entrants, okay, will try to come in. And that's a really important thing, because if you think that you have a very weak patent, okay, and you want to protect your so-called monopoly rent by bribing, essentially, all the generic, you're going to have to bribe everybody first. And chances are not all generic have the same chance of winning in court, but some of them have a better chance than others. And if it turns out that one of them actually will come in for sure, then it's completely irrational actually to try to pay people to delay, because eventually you will not secure the monopoly right that you need to pay people to stay out of the market. So if you see payment in this situation, more likely is because you have a strong patent. That is, the patent holder is more likely to think that he's going to win in litigation somehow. He's got a good chance for it, but he's still risk averse and prefer to pay for it. Okay, so you have also to ask yourself, when you have this situation where multiple entrants are in the market, whether that tells you something about the strength of the patent, and if anything, intuition tells us that it's more likely to indicate that the patent is actually not so weak. Okay, I'll stop here, and I have more to say, but obviously it will take another 20 minutes, so pass the mic.
Thank you.
Okay, thank you. I'm Esther van Zimmeren. I'm specialized in patent law, but also work quite a bit on the interface between patent and competition law. So I do not really feel obliged to start defending the patent system here. What I would rather like to do with you is invite you to take a step back, because we've heard a lot of very interesting but also very detailed presentations. So, and as we're now at the end of the day, I would like to ask you to sort of take a bird view and think also about the interface between IP and competition law more in general, because of course patent settlements are a big issue, but the struggle between IP and competition law is not something which is new. You know, you also see major discussions in the telecommunications sector, the role of standard setting organizations, and of course the actual problems may be different, but many of the questions that arise are the same. Questions like, is this a patent law issue? Is this something that should be solved within the patent system? Or is it up to the competition authorities to step in? And in the area of standard setting organizations, it's also, is there a role for the standard setting organizations, or is it maybe something up to contract law? So what you see in that particular area is that also some courts start delving into more general principles of law, such as abuse of rights, in order to try to come to solutions. So I heard, or I think it was Ingrid who also said, settlements only if the originator is abusing the patent system. That should be something you should go against. So this made me think really also a lot of this abuse of right concept. And I think that we should not always try to isolate ourselves too much in either competition law or patent law, but think on the bigger impact also in terms of interface and thinking maybe about these general principles. So it's just a kind of alternative way of looking at this. A second, more general point that I want to make, but they're all interrelated, one could say, is more of a patent governance issue. So if we claim that the competition, the European Commission as a competition authority is not the right one to say whether something is a weak patent or a strong patent, whatever that may be. So who should take that decision? It's up to the courts, we easily say. It's the patent courts that have this responsibility. But also patent courts are, let's say, in flux. There is a kind of dynamic development there. You see more and more specialized IP courts, more and more specialized patent courts all over the world. But this is not uncontroversial. So in the US, we've had the Federal Circuit Court for a long time, a specialized court. But there has been quite some discussion going on, one could say, between the US Supreme Court and the Federal Circuit in terms of the patent case law of the Federal Circuit. So it's not necessarily so obvious that patent courts will always have the wisdom to deal with these things in the right way. And so what I think is interesting, also looking more at pragmatic solutions there. So for instance, in Japan, where I've traveled quite a bit to do some more research on Japanese patent system, Japanese competition law, what the Japanese Patent Office does is they second people to the courts, to the specialized IP courts, to also help them with the technical decisions, to support them. And this kind of exchange of people. It sounds very practical, but this way you can really increase the expertise. You can also increase the expertise of competition authorities. And so in some countries, like in the US, there is already a lot of exchange between the Department of Justice, FTC, and also the USPTO. But this doesn't happen everywhere. So I think it's also time to think in terms of very practical solutions. If we criticize the European Commission for doing something not right, then we should also say, okay, how can we improve that? If the courts are maybe not always doing their job correctly, patent courts, then let's think about these concrete solutions and think about more cooperation. Like, as I said, Department of Justice, US FTC are working together with USPTO. They have these hearings where also stakeholders are being heard and where interesting kind of discussion and discourse is being developed. So patent system as such is also a dynamic thing. So in Europe, we have adopted the patent package with a unitary patent, a unified patent court. So a lot of things will change there as well. And in the US, we had the America Invents Act. So there will be an influence from that perspective as well. So for instance, what does the America Invents Act do? It creates several new procedures which allow you to challenge the patent quality. Also in other countries there have been many initiatives to increase patent quality or raising the bar initiatives. So this is the whole discussion within the competition law community, I think should sometimes also pay a bit more attention to these developments within the patent system, which are really fundamental changes and should not be forgotten. So also the presumption of validity is raised very often as the excuse for just letting patents where they are and sort of giving them a kind of holy status. But the presumption of validity, even though in the US you see it in the US code, in many countries it's more of a case law thing if it's already really explicitly adopted. It's also not uncontroversial in patent law. So the presumption of validity is being discussed by major authors, and so also in different countries, different standards are being applied. So also that is another thing that I think we should take into account. Technological developments, another dynamic issue. So we speak here about, let's say, more traditional patents, more traditional type of medicines. But there are big things coming up, especially also because of the empty pipelines. So nowadays there's more and more talking about e-health. There's more and more collaborations between pharmaceutical companies and biotech companies, pharmaceutical companies and diagnostic companies, and also the patent environment is becoming much more complex. So maybe now we're looking at limited numbers of patents in most of these cases. The patent environment is changing. So whatever we decide is the best approach for patent settlements now, we should also think about the future because the technology is changing. And the case law that we set now, or the decisions that are being made now, they will be important in the future as well. So I think that's an important element. The fact that the patent environment is becoming more complex, and so the number of patents is also increasing. So different considerations will also play a role when you think about potential patent settlements in the future in that respect. One last point, also more in this technology kind of perspective, is the business models are changing. You already mentioned that innovators are also selling generics, and also generic companies are also are engaged more and more in research and development themselves, and also developing sometimes very innovative processes or innovative medicines. So it's not so clear-cut to say, you know, these are the innovators and these are the generics. The environment there is also much more complex than is sometimes acknowledged. So in conclusion, what we've also seen is major differences between US, European Union, and also Korea and other Asian countries where there is a different approach also in the competition law, different competition law tradition and culture. Differences in the regulatory environment. We may not have a Hatch-Waxman Act, a different context in the European Union, the enforcement context and the procedural system, also with the patent package in the European Union, with the upcoming Unified Patent Court, a very complicated enforcement context is coming up in Europe. But what does that mean, all those differences? Does it mean that if the context is different, the solutions should also be different? So maybe in the US, the patent scope test is now no longer valid due to the Actavis decision. But due to the different provisions, for instance, in the Korean Competition Act, but there's a similar provision in Japan as well. Maybe it's much more logical to still apply a similar kind of patent scope test, and in a second instance do this more anti-competitive effects test. So a decision in the US does not necessarily mean that we should have the same approach in other jurisdictions, even though, of course, for companies, it is much better if the approach would be the same everywhere in terms of legal certainty, that also Benoit mentioned several times. So I really want to raise these. I'm not giving you lots of answers, but emphasizing that patent law is not as static as some competition lawyers sometimes seem to emphasize, and that also different questions may come up where some of the case law that we're setting now, some of the decisions that we're setting now may distort some of those big innovations for the future. Thank you.